Okay. It sounds like that agenda item or that modification passes. Thank you. Next is the consent calendar, consent new business. I see nothing on the consent calendar, so we will move on to new business. The first item in new business is the tree permit appeal for 0 Carroll Street, parcel 22-305-16, version 3.0. For this item, we're asking that staff make a presentation, which will include pertinent information. We're asking to try to keep that presentation to no more than 15 minutes or so. After that, we will hear from the various organizations that have come to discuss the tree appeal. First, we will hear from the appellant or their designated representative. We're asking to keep their comments to 5 minutes. And then we will hear from the applicant or their designated representative, also asking to keep that around 5 minutes. After that, we'll hear public comment and then come back to the commission to ask questions before entertaining a motion. So having said that, I will turn it over to staff to make the initial presentation.
Good evening. This is David Moore, Acting Parks and Tree Services Manager for Oakland Public Works. I am here along with Todd Lawson, who is the Arboricultural Inspector for the department. Todd was the one who handled this tree removal permit application, and I'd like to introduce him to provide an overview of this permit appeal and his response. Todd, can you please take it from here?
Yes. Good afternoon. I'm Todd Lawson, Arboriculture Inspector for the City of Oakland Tree Services. I am a certified arborist with the International Society of Arboriculture, and I am tree risk assessment qualified with the International Society of Arboriculture. At 0 Carroll Street, parcel 22-305-16, there are 7 trees proposed for removal. Tree posted number 1 is a 17-inch diameter at breast height American elm. Tree number 2 is an 11-inch diameter at breast height American elm. And tree number 3 is a 12-inch diameter at breast height American elm. All 3 trees have poor structure. The trunks of the trees are 6 feet from a neighboring building. The limbs have been removed from the building side of the tree for clearance of the building. The trees have been topped. They are in poor condition with unbalanced canopies with a likelihood of limb failure. Tree posted number 4 is a 42-inch diameter at breast height black acacia. The tree has a cavity at the soil line that is 18 inches into the trunk and goes down 24 inches. There is decay present in the cavity. The tree is at risk of uprooting or trunk failure. Tree posted number 5 is a 23-inch diameter at breast height black acacia. The tree has poor structure from overthinning. This is a type of pruning that leads to limb failure. This tree is dependent on the surrounding trees to reduce wind loading. The tree is in poor condition and is at risk of limb failures. Tree posted number 6 is a 23-inch diameter at breast height black acacia. The tree has a 13-inch diameter wound at the soil line. The wound has a significant decay present. At 20 feet from the ground, the tree has poorly attached limbs. The tree is at risk of uprooting, stem failure, and limb failure. Tree posted number 7 is a 28-inch diameter at breast height black acacia. The tree has a 28-degree lean that is over the street. At the soil line, the trunk has a 30-degree long shear crack that is at a depth of about 12 inches. The tree is at risk of trunk failure. The appellant, Mark Burdett, has submitted 7 reasons and 9 dependencies as grounds for appeal that are listed in the report that Tree Services has provided. Oakland Public Works recommends denying the appeal of Mark Burdett and upholds staff's decision approving the removal of 3 American elm trees and 4 black acacia trees at 0 Carroll Street, parcel 22-305-16. Thank you.
Thank you, Todd, for that. And now I will ask for the appellant to present, and we would ask to try to keep your comments around 5 minutes.
Yes, as soon as we are getting the correct clock up, and then I will be asking the appellant, which is Greg Clark, is speaking on behalf of the appellant, and so I will be asking him to join us. And he has, I believe he has a screen to share, so it might just take 1 minute to get him in the right area here.
Can I be heard?
Yes, we can hear you.
Okay, bear with me 1 second. Can I be heard clearly by everyone?
Yes, you can. And Zermaine, if you can stop sharing your screen so that Mr. Clark, you do have a screen to share, is that correct, Mr. Clark?
Well, just an image, but I can't see the clock if it's being shared. So that's so I think I will pass on screen sharing.
Okay.
Thank you.
So Zermaine, if we could have the clock back up, please, and then Mr. Clark will begin his comments. I can grab that. Go right ahead, Mr. Clark.
I can't see anything. I'm sorry.
Okay, 1 moment then.
Yeah. I can't see the clock. Okay, I can see it now. All right, shall I start?
Please.
First, thank you to the commissioners for hearing our appeal, and welcome to the new commissioners. I assume you've all read my report. I would like to begin with 2 points. First, as a courtesy to the hearing participants, this hearing is being recorded. The second is that as the appellant, I will speak for around 3 minutes, and reserve 2 minutes of my time to speak at the end of the discussion period to respond to points raised by other parties. It's my legal right as an appellant, and I'm exercising it. My opening statement is that the purpose of this permit application is not to remove 7 allegedly hazardous protected trees. Its purpose is to cut down these trees in preparation for development on the lot or prepare it for sale. This is at the expense of the many benefits they bring to the local residents. Evidence to this effect is based on the actions and conversations with Zachary Heineman, who has a relationship with the applicant and has been active on the lot. This information was submitted in the appeal report. Mr. Heineman is not listed as a speaker today, and perhaps the applicant will deny his involvement with the lot. However, we have witnesses who will testify today on Mr. Heineman's actions and conversations that support this assertion, both on the property surveys for the lot and administrative actions on the tree permit undertaken by him. My point is, for the applicant to use a non-development permit to remove trees for development purposes is illegal under California state law, specifically the Unfair Business Practices Act, also known as the Unfair Competition Law. It is illegal to allow one owner developer to bypass actions and laws that other developers or citizens have had to follow for development, for example, the California Environmental Quality Act. Further, the City of Oakland and tree services have been warned from the very start of this process that this was occurring. By continuing with the process, they are actively complicit in helping the applicant to break state law. These actions expose the city to legal and financial repercussions. And as a planning arborist from another Bay Area city related to me when I described the situation, it should be extraordinarily concerning for the city administrator. In his words, it's a can of worms. If the commissioners choose to approve the permit, they too will be actively complicit in subverting state law and can be held accountable for it. My second point is that several statements from tree services in the response to my report on the various benefits that the trees provide are wrong. They directly contradict the Protected Trees Ordinance under intent and findings, and other speakers will discuss this. I will reserve the rest of my time to speak at the end of the discussion. Thank you.
Thank you. And we do have time later on in the agenda for commissioners to pose questions to the applicant and the appellant. So you do have 2 more minutes if you'd like. We have time for the questions later.
Thank you.
Okay. If you would like to cede the rest of your time, then we can move on.
I believe he wishes to return and continue his speaking at a later time, was his comment.
Okay. Well, I would ask that finish the initial comments here, if you have any, and we will have time later to ask questions and for him to respond.
I do this under protest. I do have the legal right as an appellant to reserve time for another period of the conversation. So these comments will be made under protest.
I'm not sure which comments you're holding, but
well, I was waiting to hear what other people were going to say. For example, the applicant, because there may be points that I wish to respond to that I can't respond to until I've heard what they've said.
Okay, I understand. Let's move on then.
So
you can reserve your time.
Okay, thank you.
Okay.
If we could reset the clock, please.
Okay, then let's move on to the applicant or their designated representative.
Yes, Mr. Cohen. And Mr. Cohen, when you are ready, please go ahead and make your comments.
Okay. Good evening, everyone. I'm Barry Cohn. I am the trustee of the Janet A. Martin Trust. Janet passed away on June 3rd of 2020, and I became the trustee of the trust. It is my fiduciary obligation to protect the assets of the trust and to understand what those assets are worth. So I did investigation, understanding what the property's worth, what it could be developed, what's happening on the property, and I used Zach Heineman to do some information gathering for me, and in that process, discovered that the trees were in danger of being falling down or having limb failure or whatever the potential risk was. And determined that we should take the trees down. We have no application in for permit to develop the property. Won't deny that eventually someday it may get developed, but that is a long time, I suspect is a long time off, because certainly in this environment with COVID and the condition of the market, it's not going to be developed for quite some time. But I do have a liability with regards to the trees, with their potential falling or doing damage. The one leaning clearly would fall on anybody potentially walking on the sidewalk next to the property or the cars that are parked adjacent to the property. And any one of these trees could fall on the building on either side of the property and expose the trust to significant liability. So in that, with that information, I submitted the request to bring the trees down. As much as I hate to do it, but I think in the best interest of the trust, it's much safer and it limits the liability of the trust by doing so. And as you can see in the report, the city confirmed that these trees are at risk, and I can't in good conscience leave these trees up for just falling down. It's not a good fiduciary responsibility to do so. And the fact that this information is now even more exposed and publicly exposed, I expose the trust to significant liability if in fact these trees are left up. And assuming this appeal is denied, I would move swiftly to make certain that these trees are taken down so that the trust and no one's health or property is exposed or in potential for damage. Certain simple, that's ultimately what I'm trying to do. I'm just trying to protect those around us as well as the trust's assets. Thank you.
Okay, thank you for your comments. And now I will ask the appellant if you would like to use any of your remaining time to respond.
I would. Would you like to reset the clock, Ms. Riley? So
Please
my first
reset
comment.
for 2 minutes. I'm sorry, Mr. Clark. Zermaine, can you please reset to 2 minutes?
Okay, go ahead, Mr. Clark.
Okay, so my first point thank you for the comments from the applicant, and I appreciate his concerns. However, my first point is that Mr. Hyman isn't a trained arborist. He's a trained architect and isn't in a position to assess the health of the trees. On that basis, I can see the trees out my window and they look extremely healthy. They're not damaging the buildings. And in fact, the permit applicant fraudulently implied that they were damaging 228 Carroll Street. So I would, that's my rebuttal to that. I would also like to know that if the commission chooses to deny the appeal and grant the permit, we would like to know the date or timeframe when the permit will be issued, because it will likely go to court. And we'd like to offer the opportunity to the courtesy to the city attorney to meet to discuss the residents for other options. The second is that if it's in the commissioner's discussion that you feel that just one of the trees is a safety issue, we ask that you recognize and consider other options in bringing all 7 trees down, so that just on one tree. However, I'd also like to note that bracing is a recognized arboreal practice to preserve a leaning tree. Now, these points in no way concede on the argument I made that this is breaking California state law or other arguments that will be raised by appellant speakers. I think it's crazy that all 7 trees are a health and safety issue, that all the 7 protected trees on the lot. This permit was applied for development-related purposes. California unfair business practices state law applies and it's being violated, and parties should be held accountable for that. The permit application is illegal and we think it is in the interest of the city to deny it as a minimum on this basis. At the very least, the commissioners should refer it back to the city for comment or as a development permit. Thank you.
Okay, thank you. So I will close out the comments from both the appellant and applicant, and I will move now to hearing public comment. So we'll give a couple moments. If there are members of the public who are interested in speaking on this item, please use the raise hand function and staff will be calling on you. Okay, so we'll be allowing 2 minutes each. Staff, whenever you're ready.
Sure. Susan Borrow, please unmute yourself and make your comment when you're ready.
Yes. Sorry about that. Okay. My name is Susan Burrows. The degree with which Tree Services issues decisions contrary to law is mind-boggling. PRAC simply cannot approve such decisions. I ask that everyone listen carefully to what Tree Services falsely states is the law. Their words are directly opposite of what the Protected Tree Ordinance actually says. The Protected Tree Ordinance reads in its opening paragraph, quote, "Among the features that contribute to the attractiveness and livability of the city are its trees." In the official documents for this hearing, Tree Services writes, quote, "The Protected Trees Ordinance does not have a section pertaining to beauty, privacy, urban heat island effects, noise pollution, or air pollution as criteria to consider when making a tree removal permit decision. It does not have a section pertaining to air pollution, air quality, tree canopy coverages, birds, or wildlife. Therefore, tree services cannot consider these topics as criteria for making a tree removal permit decision. Reading from the PTO, by contrast, trees have significant psychological and tangible benefits. Trees contribute to the climate of the city by reducing heat buildup and providing shade, moisture, wind control protection for natural resources, oxygen for the air, and habitat for wildlife. Trees contribute to the economy of the city. In place of all this and more, tree services substitute in words not in the PTO. These are words contrived by Public Works. Tree services can only consider the biological and/or structural condition of a tree and its immediate environment as a reason to remove or preserve a tree.
Thank you very much for your comments.
Such as the one before.
Mr. Callahan, you are welcome to unmute yourself and make your comments when you're ready.
Yes, thank you. So this is James Callahan here. Oh boy, yes. Are we in now?
Yes, we can hear you.
Thank you so much. My name is James Callahan again. Once in a while, what is revealed during some special appeal hearings can help to serve to transform our city for the better. Tree Services has put in writing openly and for the first time just how it makes decisions around hundreds of thousands of trees for years. How it makes decisions in the parks, in the schools, next to hospitals, for homes, for street trees, for entire communities, everywhere. There is one protected tree ordinance. Their words in this decision apply everywhere in Oakland. You have just heard from the other speaker as she reads the actual protected tree ordinance counterposed to what Tree Services falsely claims it says. If Pratt does the unfathomable and denies the appeal and supports Tree Services' false interpretations of the law, we are prepared to save the trees. Any fair and reasonable hearing would deny the permit. The Alameda County Superior Court will be next, and the judges can save the trees. Alas, what the community cannot do, and the judges cannot do, is save Pratt commissioners from what they decide. Their decision, if they did that, would be overturned. Everything would be in the public record and now become part of case law, and they will forever have to live with the decision of an unconscionable decision. Read what Tree Services has written, counterposed to Protected Tree Ordinances, contrast their words to the laws, and it quickly emerges just how Tree Services itself, their decisions are truly a serious threat to public health and safety. In a similar Pratt hearing in the past, Tree Services even argued that they have no responsibility whatsoever for climate change. Talk about health and safety issues. Decisions such as these are disastrous for the parks and the funding, and it's up to the practice to decide if they stand with the law, the community, and the environment, or with this disastrous decision that Tree Services puts forward. Thank you very much.
Thank you for your comments. John Heim, if you would like to unmute yourself, you can go ahead and make your comments when you're ready.
Yes, indeed. Can I be heard?
Yes, we can hear you. Please go ahead.
Oh, good evening, commissioners, and welcome new commissioners. My name is John Heim, and for 20 years, it's been my privilege to be counsel to the partner Florida, who own the adjacent property at 2208 Carroll Street, where lies an apartment building. It's my understanding that the applicant seeks a non-development permit for tree removal, in part at least on the basis that the roots of these trees are damaging the foundation of my client's building. In fact, the roots and the trees are not damaging my client's building. In fact, my client perceives no threat or risk of root damage or tree damage to his building. The trees, as he just measured them today, stand 18 to 20 feet from his building. Indeed, the trees give great benefits to the building. There's urban canopy and shade, there's cooling, there's appearance and ambiance enhanced by the trees, and most important, the trees are appreciated by the building's tenants, and we like happy tenants. Some time ago, Zachary Heineman told my client, Mark Baradet, that the trees were to be removed to facilitate development or sale of the property to a developer. He said this at the time of an informal survey. My client understands that Mr. Heineman and the applicant are working together in cooperation. I don't know. And I don't presume to know the applicant's motivation for tree removal, but I do know this. If it's motivated by concern about damage to the foundation of my client's building, none is occurring, none is threatened, none is anticipated. So let's all save the effort and loss to a city that named itself after trees.
Thank you for your comments. Maura, if you would like to unmute yourself, you can make your comments when you're ready.
Thank you. Can I be heard?
Yes, we can hear you.
I was a tenant at 2208 Carroll Street. Thank you to the PRAC board, by the way, for hearing me. I was a tenant at 2208 Carroll Street throughout the spring and summer when Zachary Heineman was surveying. Throughout this time, he was there very frequently. And I spoke with him between 4 and 5 times on regular walks around the neighborhood. In these conversations, he was extremely clear and very direct about his intention and desire to develop and build, not as a long-term potentiality, as Barry Cohen claims, but as the reason that he was on site. He even spoke specifically to me about the type of building that he was hoping to build. This is a non-development permit that is being applied while question on who knows what, but while there is an intention fully to develop. So based on that information alone, I'm an eyewitness, and I have also witnessed Zachary talking to someone on site about intention to build, which I don't know if that person is Barry or not, but this should be a non-issue. This is a fraudulent and illegal permit. And if PRAC does not stop this to investigate, then PRAC is complicit in this illegality. This is a matter of public record, this meeting. And again, I am an eyewitness that is reporting a fraudulent and illegal permit. There was full intention to build. This should be a non-issue. This should be denied and immediately go to investigation. Thank you.
Thank you for your comment. Derek, if you would like to unmute yourself and begin your comments.
Yes, hello, thanks.
Thank you.
Hi, my name is Derek Schubert. I'm a civil engineer, landscape architect, Adams Point resident. For the last 5 years, I've been volunteering as a coordinator of tree planting community-based organizations here in Oakland, the Sierra Club Tree Team, and more recently, Trees for Oakland, a project of the Oakland Parks and Recreation Foundation. I've been following this case for the last 5 months, talked with Greg Clark for the first time in August 2020. I'm here to say that trees in Oakland need an advocate. And if Tree Services is not that advocate, or if the PRAC is not that advocate, I don't know who is. Tree Services and PRAC have the broad view over trees throughout the city. And so although we may be focused on one small group of trees here, we need to see them in the context of trees throughout the city and in a cumulative way, seeing that this permit has bearing on other issues throughout the city. One issue in the report, the response by Tree Services to the appeal, is that the tree protection or the Protected Tree Ordinance does not specifically mention the ECAP, the Equitable Climate Action Plan, and therefore Tree Services must not consider the ECAP. I am concerned about that logic. The ECAP is an aspirational document. It has policy implications, and it reflects the desire of Oakland's citizens and Oakland's politicians to protect existing trees and to plant more. So my question then is, who would stop Tree Services if you did consider the ECAP? I think Oakland's citizens want you to consider the ECAP. Oakland City Council does. So the only ones who probably would not want you to consider the ECAP are the people who want to cut down trees, but are they the ones you serve? I don't think so. Thanks.
Thank you for your comments. And identified as A. Colvin, if you would like to unmute yourself, you can go ahead and make your comments when you're ready.
Thank you. My name is Andy Colvin. I'm counsel to Barry Cohn as trustee of the Janet Martin Trust. I'd like to make three fairly simple points. I think the discussion and the report and Mr. Lawson's discussion at the beginning of this session clearly shows that these trees are damaged. They are dangerous. It's not a question of whether they are affecting a foundation, but the real concern is the liability that will occur if the trees were to fall. I'd like to point out that's not a liability Mr. Cohn has been able to insure against. So he is sitting out holding all of this liability. He has done everything that was required under the ordinance. And
are we still waiting on a speaker?
Excuse me? He has done everything that was required under the ordinance. Staff agreed, decided that these dangerous trees should come down. Secondly, the discussion about what is good for the city of Oakland is certainly a larger question than these 7 trees. But this is a private citizen who is now being asked to shoulder a very undue burden. And finally, I'd like to state that I think the real rub here for the appellant and those speaking on his behalf is that they've enjoyed having a vacant lot next to the and they're very, very worried about development. There is no application for development. There's no agreement on development. And when and if that happens, they will have more than adequate opportunity, and it won't turn on whether or not these trees have been taken down. But in the meantime, we are faced with a situation where if, perish the thought, one of those trees were to fall, it will all fall on Mr. Cohn. Thank you.
Thank you for your comments. Kent, if you would like to unmute yourself and make your comments when you're ready.
Yes, thank you. Thank you. Take the discussion up 10,000 feet, regardless of what the motivation is. I'm not here to speak to that, but I do think in a situation when the organization decides that there are trees in Oakland that are unhealthy or unsafe, that there needs to be a part of the policy, which is to have an adequate replacement of the trees within the city so that the net loss is negligible. Now, these trees that are in discussion here are quite valuable. They're quite aged and quite mature. So I would just, throw out a number, say 100 trees planted in a conserved area, a protected area, city area, would be a way for the liability to be relieved and the environmental benefits maintained for the city. So I'm just throwing that out because I know a lot of jurisdictions have a situation where when a tree is unhealthy or unsafe, they allow it to be removed, but it has to be appropriately replaced for the community benefit. Thank you.
Thank you for your comment. Ms. Posada, if you would like to unmute yourself and make your comment.
Yes, thank you. 2 points. To me, there's something very dangerous about when a person has private property and they're being dictated to by outside sources about what they can do on their property. That's dangerous. Second, I'm living here in California, originally from New Orleans, Louisiana, because of Hurricane Katrina. I didn't lose my home because of the water. I had a large tree in front of my home, and the roots of the tree, when the wind was high, pushed my foundation up, completely cracked my foundation. And the insurance people told me there was nothing they could do to save that house as far as investing in it. It would be a waste of money. So I have an issue with trees. I didn't know this, but once a person has realized privately that there's an issue on their private property that could endanger their property, that should have some leverage. And it's just very dangerous to me to have someone dictate to you about trees on your property. I lost my home because I didn't know that the roots of these trees, this one tree was under my foundation and completely cracked the whole house foundation. So you guys go on and love your trees, but trees sometimes can be a problem. Not all the time is it a benefit. And so serious consideration ought to be given when private property owners say this is a problem for me. Thank you.
Thank you for your comment. Would the member of the public with the last name Danya please unmute yourself? We can hear you. Go ahead and make your comment when you're ready.
I think you're talking about me. I'm Uriel Dana.
Yes.
I've been living here since 2004 at Carroll Street. And thank goodness we don't have hurricanes, and the building was just retrofit and there was no root damage from any of these trees in our building. I have a couple of, I've itemized my way back in September of why I object to the removal of these trees, but so I won't go into those, but I do have a couple of issues I want to cover here. The first goes back to May, June of 2020, before this permit was applied for under a fraudulent non-development application. Zachary Heineman was surveying the lot. I was concerned about the owner who had been systematically damaging the trees and removing some trees illegally for years. I asked him about the trees, if they were going to take any more down. He said he didn't know anything about the trees, but that he's just doing a general survey for the neighborhood. Later, he asked me for access to survey the inside of my garage, which I was startled and I felt uncomfortable with. And he told me that the owner of our building, Mark Baradat, had asked him to do some survey work on his property. So I felt uncomfortable, but I didn't want to inconvenience the owner. And I asked him how long. He said about an hour. And I said, look, I'll just back my car out and I'll wait here for you to be done, because I had antiques and some other things valuable in my garage. And he went in there for like less than a minute and took what seemed like a 360-degree photo of it. So that was a lie. So those are two big lies. So this process seems to be surrounded by furtive and deceptive business practice from the city of Oakland and the permit applicant, and both seem to ignore its citizens and environmental implications. And that's all I have to say right now. Thank you.
Thank you for your comment. And Sarah Silver, if you would like to unmute yourself and make your comment.
Hello, thank you for the time. I appreciate it. I am a resident of 2208 Carroll Street, and my apartment faces the trees.